Injunction. Injunction is to order someone not to do or to remove the results of infringement. Here we learn about how Japanese civil code provides about the right to claim an injunction. The right to intangible things is called real rights. In Japanese, things is termed bukken. Real rights are ownership, right to use, right, security rights, and possessory rights. Please see the illustration. Among the four real rights, possessory rights is unique. Ownership contains all real rights. A part of the right to use and security right contain possessory rights. However, in some cases, possessory rights exist on its own. For example, the possessory right of the founder of the thing is protected. He or she does not have ownership, right to use, or security right. The lessee of a room can use the room. This is because the lessee has the possessory right for himself or herself and not for the owner. The uniqueness of possessory rights is to protect the situation. It is independent of the cause of the situation. Japanese Civil Code Article 180 provides that possessory rights shall be acquired by holding things with an intention to do so on one's own behalf. Our possessory rights permit three actions: action for maintenance, actions for preservation, actions for recovery. Action for maintenance include actions to retain possession. Actions for preservation include avoiding threat impacting possession. Actions for recovery include recovering lost possession. From maintenance to recovery, the power of possessory action becomes strong. It is important that the possessory right is a cause of injunctive relief. If the party wants to stop the nuisance of noise, smell, or polluted air, an injunction can be requested by the action for preservation. As illustration, once soil came from the neighbor, the party can claim to remove the soil on the land by the action for recovery. Topic: Increasingly aging society and real estate. We will learn about property, real estate, in an increasingly aging society. Vacant house problem. In Japan, for a long time, there was a myth that real estate is the most valuable property. We believed that the price of land will not decrease. Because of concentration of the population in metropolitan areas, the population of rural areas is increasing. Because of an increase in one-person household, the number of real estate without a successor or abandoned by the successor is increasing. The increase in the number of vacant houses is undesirable for public safety and disaster prevention. The Act on Special Measures concerning promotion of countermeasures against vacant houses was enacted in 2014. Article 1 states that vacant houses without proper maintenance can have serious detrimental effects on the local residents in terms of disaster prevention, sanitation, aesthetic value, etc. This problem occurs in metropolitan areas as well. The myth is discarded. Ironical, real estate becomes minus property. The Japanese pronunciation of real estate and minus property is the same. Problems emerged by vacant houses. As the progress of super-aging and decreasing birth rate, it is difficult to manage land and houses that aged live in. The aged does not have cash and cognitive decline. They cannot continue to manage their property. Relationships among relatives become weak. After the death of aged, it is difficult to find successors of the vacant house. Which law should govern the vacant house problems? Civil law, administrative law, or criminal law? To solve the civil law, who should be defendant? The aged lacking cash or cognitive capacity cannot realize the judgment order. To solve by the administrative law, the cost of administrative substitute execution removing vacant house will shift to taxpayer. Is it rational for other taxpayer bear the cost to protect property rights of the aged? To solve by the criminal law, we need to think about what is a criminal act. Is it a crime that the aged keep their house? Analysis. Restriction of property rights. The principle of absoluteness of ownership is the base of liberal economy and self-autonomy. In this lecture, we saw some cases required revision of the principle. We will discuss about the restriction of property rights. The animation is in front of a hospital. That ambulance come repeatedly. Patient of pandemic influenza will come to emergency hospital. How does it affect on the neighbor to the hospital? The reasons of restriction of property rights of neighbors are different. About Yokota base, the restriction is because the political, diplomatic, or national security. About new road of Haneda Airport and vacant houses, it is because the public welfare. About state of emergency, the reason may be combination of political and public welfare. We need to discuss about the extent and conditions of restricting private rights considering the principle of absoluteness of ownership.